Morning. Mr. Long?
Morning, sir.
Good morning, Your Honor.
Mr. Parry? We have a hearing scheduled in Lopez, a continued hearing. Mr. Mills, I understand they won't be bringing Mr. Lopez over until this afternoon at about 1:30. Okay. But we do have before the court matter of State versus Long. Mr. Long, you have filed a notice of motion or an application to the court regarding a request to the court to order certain tests be done to a cigarette butt that was in evidence at your trial, and that certain ballistic tests be done to some shell casings. And that really is a motion, not a post-conviction relief application as I see it. But I think you also have now made an application to have the court consider an additional post-conviction relief application based on incompetent counsel. I'm prepared to, I read your brief, I read all the supporting documents.
Page 74?
Well, I read whatever you sent me, Mr. Long.
I'm asking if you have page 74 because...
Page 74 of what?
Was that missing from the court copy?
Of the brief? I have page 74 designated as page 74. Now, I read all the material, the transcripts that you submitted, and your correspondence and everything else. Now, I had you read it here so you could make oral argument about anything that you want to make argument about. I hope it's not going to be a repetition of what you said in your brief, but it's up to you what you say. And I'm prepared to hear your application at this time, sir.
Okay, Jan. Good morning, Judge.
Good morning.
First of all, Jan, I'm kind of awkward here because... Can I have this handcuff taken off?
Well, you have one hand free.
Okay, well, I use both of my hands, and I have my stuff that I want to refer to. And it's kind of uncomfortable. Plus, they took my pencil. I need something to write with.
Are you right-handed?
Yes, I do.
Okay, we'll give you a pencil to write with, but you're going to have one hand cuffed for security purposes. I don't make those regulations.
Is a new rule or something, Judge?
Well,
every time I came before, you always had them take them off. So I mean,
as long as you have enough freedom of movement to do what you have to do.
You know, because this officer told me when I walked in that you said only take one handcuff off. I said leave them both on until you come in, so that I can ask that you take both of them off. And you know, I mean, all the time I've been coming here, I never had a problem with the handcuffs. And sometimes it can be a little restrictive, and it can also be a little intimidating.
Okay, well, I'm not going to change my ruling on that.
Okay, no problem.
If it gets to the point where that becomes a problem that I conceive to be a problem, we'll deal with it.
Okay.
No.
Your Honor, and I'm just stating for the record some factual background without going into the everything that was said in my brief.
Right.
I believe you this time when you said you read it. 1990, when the Supreme Court reversed my capital murder conviction, they reversed the conviction in order to do the trial. And the state decided that they wanted to dismiss the murder charge and leave me sentenced on the remaining charges. So they dismissed it. I came here in January 93, and at that time I asked that the state would stipulate that the dismissal was with prejudice, which would obviate the need for having to argue further arguments. The state didn't want to do that. So you made the ruling that the murder charge is dismissed with prejudice. So those other arguments that I had intended to make at that point, if you remember, didn't have to be addressed. Okay. I subsequently filed a motion to have my sentence changed due to the fact that the longest remaining term that could be against me at that point was 20 years served 10, and I had 11 years in. The state says, oh, we made a mistake. We threw the murder charge out by mistake. And you let them resurrect the felony murder charge. And we had some argument on the felony murder charge since then. The last time I was here, since then, the New Jersey Supreme Court decided State versus Horace Branch. And that case supports my position, is that you cannot have a felony murder charge without an underlying predicate felony. In this case, the underlying predicate felony was the armed robbery charge at the liquor store. And that charge was dismissed too. So, I'm sentenced on that felony murder charge that you brought back to life with 30 years without parole. When in fact, that I still contend that this is a legal sentence.
Mr. Ronald, excuse me for interrupting, sir. Wasn't that all litigated in...
Your Honor, whatever was litigated prior to then, the only reason that it would have any substance after that is because Branch was decided in August 98, and I haven't been back here since then. Okay, so I believe that you are bound by the New Jersey Supreme Court case rulings. Now, whatever's been litigated at one point or another, it doesn't just go away if it's wrong. I mean, maybe you don't like it, maybe the prosecutor don't like it, but if it's wrong, it's wrong. So the Supreme Court ruled in August of 98 that a felony murder charge does not stand without an underlying predicate felony. And to that issue, I ask that you address that. You don't have to, but I ask that you address that because it will be taken back up. Okay, so to that extent, I put that back on the record, that felony murder charge does not survive without an underlying predicate felony, which in this case has been dismissed. Furthermore, Judge, I've brought some arguments to you regarding excessive sentences that remain on the other charges. And I never really addressed the excessiveness of the fines because it had never been a problem. Nobody was taking anything from me. But since then, they started taking all my money off my account. And the Supreme Court ruled, in their opinion, in 1990, that certain things must happen back in the law division. And among those certain things was that there would be consideration of excessive sentences in the law division. That never happened. They said, we take the easy way out. We'll throw the murder charge out. Leave them sentenced on everything else. We won't deal with it. Nobody's ever dealt with the fines. We brought that up. That was litigated before, except to the extent that nobody ever dealt with the fines. But since then, I found the case of State versus McQuaid. And State versus McQuaid allows those type of matters to be decided by this court in this form, whether you want to do it or not. Just on the record. Which is at 147 New Jersey, page 464. Okay. Now, Your Honor, I have another problem with that because the judgment of conviction that you entered in 1994 when you brought the murder charge back without giving me the new trial act, you only had on there a total VCCB penalty of $25. And you didn't state that on the record, which it really didn't matter because it was only a $25 fine. The JOC that went down to the Department of Corrections had total VCCB $25. So, in my mind, not that I'm agreeing with this conviction or this penalty or this fine, but in my mind, the judgment of conviction that I'm being held on, and that should be reflected in my classification files, should be a $25 fine. They had in their computers in excess of $20,000 fines. And then last summer, they started taking my money. They started taking all my money off my books. So I said, wait a minute. My judgment of conviction says $25 fine. The $25 fine that I'm expecting on my judgment's conviction. Since then, somebody sent something to one of your clerks. They said, oh, we'll amend this. And they amended that. But I don't think that that could be done. I didn't have 2 judgments of convictions. I only had 1. And it's only 1 judgment of conviction that's holding me in prison, not 2. So I'd ask that you address that. In addition, this is 180-something days credits that I brought up before, which affects my classification. It deals with from the time of my arrest to the time of my indictment that I was never given credit for. Now, the judgment of conviction says 823 days, I believe it was. But if you look at the Supreme Court opinion, the Supreme Court opinion obviously gives me credit because it says it's a 971-day pretrial delay. So it's a problem there. It's a problem that you, for whatever reason, didn't want to address. And I put those on the record too. When I came here last January, '98, I asked that you recuse yourself because of bias, and I made a pretty good record. When I came here last March, I asked that you recuse yourself because the bias was still reflected in when you said something about you had to read the transcripts. I thought that you'd already read the transcripts, like you said this morning, that you read the transcripts and stuff. I believe you. If you did, I believe you. But, again, I don't waive that issue with respect to what I argued today. I've been incarcerated over 16 and a half years for crimes that I didn't do. And there's a way to prove my innocence, and that being the DNA. At the time I went to trial in 1985, DNA hadn't been known about. And then when DNA came out, it was only for rape cases, those type of cases. Since then, the technology has developed that they can get DNA off of the back of a stamp that had been licked 100 years ago. So the cigarette butt in my case is very important, you know, despite how the prosecutor tries to minimize it, which I would like to address once he makes his statement. I would like to have that cigarette butt submitted for DNA testing so that I can prove that I was not the person who left that cigarette butt there, and so that I could convince a court to grant me a new trial. In deciding whether a new trial should be granted, the court has to look at the totality of the case, all of the evidence in the case. Whatever was used to convict and to decide whether a reasonable jury could have found guilt beyond a reasonable doubt. Now, if you look at the evidence in this case, first of all, there was absolutely no physical evidence in this case that linked me to any crime, except perhaps the cigarette butt. And the way that the prosecutor did that at the time of the trial was they introduced all my canteen slips and the evidence to show that I smoked Newports. Therefore, he left the cigarette butt. But the state relied heavily on Paul Pettigrew, jailhouse witness, who said I confessed to him. I know Your Honor is not ignorant to the problems that you have with jailhouse witnesses.
Oh, listen, you talking shit.
Prosecutors giving them scripts to fill in some missing gaps in their cases. But the jailhouse witness was significant in my case. He came in the case after I had been incarcerated or confined in the county jail 28 to 26 to 27 months. So all that time, I'm trying to go to trial. They're trying to offer me a deal. I'm saying, no, I'm not taking the deal because I didn't do it. Now they come up with the jailhouse witness 2 days before my trial started. And I don't know if Your Honor fully understand how this happens. But 2 days before my trial started, the prosecutor's office terrifies my aunt. It tells my aunt, Ronnie confessed.
Objection.
Hold up for a second.
Objection. No, I'm objecting.
Okay.
To the extent that the defendant is raising information outside the scope of what's verified in the petition, I'd have to raise an objection. Plus, she's recounting information which is hearsay, as much as it would relate to something that
Your Honor,
comes to beyond.
it's not outside the scope of the petition, because that's part of the court's duty to determine the evidence that was used at trial.
Well, let me rule on the objection first of all. You should be limiting your argument to what you put in your brief and what you put in by way of certification and support for the brief. However, since this is not a trial and there is no jury here, and for completeness of the record, within certain limits, Mr. Long, I will permit you to say whatever you want to say.
Okay. Your Honor, the prosecutor's office came to the trial 2 days before my trial started, and had my aunt say that I confessed to her in so many words. Ronnie told us that your son is involved, so you better tell us something to get Ronnie, else we're going after your son. She came in here, she was terrified. She would have said anything to protect her son. Now this person I was supposed to have told her son was involved was the jailhouse witness. The jailhouse witness carried the bulk of their case. Your Honor, if you look at the entire case as it is, and you have to also consider something that you don't want to consider, that this case was about race because the prosecutor's office, not this prosecutor, but his partner, made race an issue. He called me a brother, equal opportunity shooter. Those were ugly euphemisms that had no reason to be in the trial at all. And the judge correct at the time did not allow me, a voir dire, to ask jurors, do you know any black people? Do you associate with any black people? Etc., etc. It was limited to one single written question. So there was a racial climate in the case that was something that I had no control of. But those things went into the conviction. The Supreme Court said that shouldn't happen again. And they were under the assumption that I was going to get a new trial. I was under that assumption too, that I was going to get a new trial. Okay, so I never got to new trial. The DNA evidence becomes significant because when you look at the totality of the evidence, it's not there. And I shouldn't be in this situation only because I'm black. I know that a lot of people, a lot of white people in particular, get uncomfortable when people say, this is happening to me because I'm black, and they try to use skin color. But it's clear as day in this case, Your Honor, this state has absolutely nothing. They never did, and they never will, because I was not the person that committed the crime. This case is 16 years old. It's still in litigation. And it'll probably still be in litigation if the court rules one way or the other, because they're going to appeal. But there's something wrong here. And you have to look at this. Your Honor, I filed this motion regarding bullets. There were 3 shooting victims. All 3 victims were allegedly shot by a .25 caliber handgun. A gun which has never been recovered, or at least to my knowledge, it's never been recovered. Maybe that it was recovered. Maybe it may have been recovered while I was in jail waiting to go to trial. Or maybe it was never recovered. Since my trial, I found out about IBIS. I submitted something to the court to this effect. At the time that I went to trial, they tested bullets with the microscope. Microscope and the naked eye. With this IBIS, which is an acronym for Integrated Ballistics Identification System. They use cameras and computers. They could tell conclusively whether bullets match each other, and also whether they match other crimes that may have been committed while I was in jail. There's 2 things that I asked the court to do. I asked the court to submit the evidence bullets to the ceasefire program, which one we have in New Jersey, is the Essex County Sheriff's Department. They have the IBIS computer. And the second thing is to enter it into the NCIC, so that we can find out if the gun or a particular gun has been recovered. I believe that if they were retrying a case and they need that information, they can do it. likewise, I should be allowed to have the same access to make these arguments to the court.
Good job, Ronald.
Your Honor, I believe you
Good
read my
job.
arguments regarding effective assistance of counsel, and I read the prosecutor's
You need
letter.
to sit there patiently, Mr. Hall.
That he said I was given an opportunity to raise an effective assistance of counsel. He said that at that time I didn't. Well, we know what happened at that time. At that time, the murder charge had not been brought back. At that time, the murder charge had been dismissed with prejudice. So I shouldn't be bound by a particular decision that I made, and then the prosecutor comes along and makes another decision or makes a request, and then the court makes a decision. Okay, Mr. Prosecutor, you made a mistake when you threw the murder charge out. 3 years later, I'll let you bring it back. But, Mr. Long, we gave you the opportunity to raise an effective assistance of counsel, and you did. It's not fair. So, I think the court should entertain those arguments on ineffective assistance of counsel. Plus, on top of that, I don't think the case law states that if you raise ineffective assistance of counsel, if you're given the opportunity and you don't take it, then tough luck. Because certain things happen in certain cases. I don't think there's any hard line rule that states that you can't pursue a particular course of defense, or that you must pursue a particular course of defense because somebody suggests that to you and say, do you want to do this? No. I handle my case, and they handle their case. So the fact that the court said, Mr. Long, do you want to raise ineffective assistance of counsel? At that time, I didn't. Doesn't mean that, okay, you waived it, because I didn't waive it. In fact, I made it very clear on the record. I was never happy with the services that I received from the court-appointed attorneys. And I'm still not. And that's reflected by what's happened to me. Because had I been given adequate counsel, I'd have been home years ago. You know that, Judge. You're looking at this case. You know what kind of case you have here. The prosecutor knows that. This is not your average case. This is not a case where there's overwhelming evidence. This is a case of status quo. Listen, everybody made a rush to judgment when the case first started. And, Judge, unfortunately, you inherited a bad case. So you have to kind of clean up after people. Not necessarily Mr. LePerry, because he inherited a bad case. But you plan a thing of, well, let's see if we can clean this up. And it's not fair. So as far as my claim of ineffective assistance of counsel, unfortunately, I can't call Barry Cooper, because he's passed away a long time ago. But I can't call the others. And those things now become relevant in light of my argument with the DNA, which I never knew that I could raise DNA on a cigarette butt. And in light of the argument with the request to examine the bullets. And also in light of the argument that I have illegal sentences, 7 maximum consecutive sentences that remain in effect, concurrent with a conviction that I was never given a new trial for. And as I maintained in January 98 and March 98, I maintain today that I don't think Your Honor can fairly deal with these issues because of the issues that you have made previously in this case. And I still maintain that Your Honor should recuse himself and let another judge handle these issues. And with that, I refer to the gentleman to my right.
Thank you very much. Mr. LePerry?
Ronald, by way of background, there were some issues that have already been litigated, and the issue of the sentence on the felony murder has been through the courts, even federal court, and has been upheld. Contemporaneously, there was a challenge to the other sentences, and they've been affirmed by express adjudication. So And those really are not the issues before it, but there were some comments by way of background that I felt I ought to address. With respect to the procedural bars, the judgment conviction initially entered in this matter was in 1985. There's a 5-year limit on the bringing of post-conviction relief applications. I submit that in this case there's been no credible showing of excusable neglect, irrespective of what comments were made by Your Honor at the time, whether you may have invited counsel to raise other issues which he may have been contemplating raising. But regardless of what the circumstances are, you're governed by the 5-year time limit. The fact that he was invited, I submit, even makes the circumstances worse. And this application is brought even years after that, after the resurrection of the felony murder, or imposition of sentence on the felony murder. So there's been even inexcusable delay after that.
You would have said
I submit
resurrection
that
of the felony murder?
the whole matter
Can't resurrect
should be
something.
dismissed summarily on the basis of the time bar. But I'd want to...
Which part are you talking
I
about?
submit everything.
When you say the whole matter, now what are you talking about?
DNA, the ballistics evidence, and the effective assistance issue. I understand Your Honor's preliminary comments to the effect that you wouldn't view those motions which the defendant captions to impound evidence as post-conviction relief. But I don't see that there's any other avenue into court other than through those rules. I think you have to be bound by the procedural bars, no matter what type of relief you're seeking for, unless it's a reduction of sentence or something to that effect. So I think the defendant has to come into court and show that there's a good reason why he wouldn't have brought those DNA motions earlier, the ballistics testing motions earlier. The technology may not have been in existence at the time of the conviction, but it certainly has been within the last 5 years, at least with respect to the DNA. With respect to the ballistics, there's really been no credible showing that this method is substantially superior to the methods that are still commonly used in courts through forensic experts in ballistics, the type that was used in this case. So the state would urge that all those issues would be subject to all the post-conviction relief procedural bars. The 5-year and failure to raise an appeal to the extent they'd be relevant to